Good day everyone, our topic is about mediation. So let's talk about, first let's talk about what are the terms applicable to the segment on international commercial arbitration. First is ad hoc mediation, means any mediation other than institutional or court annex. Institutional mediation means any mediation process conducted under the rules of a mediation institution. Court annex mediation means mediation process conducted under the auspices of the court and in accordance with Supreme Court approved guidelines. After such, court has acquired jurisdiction of the dispute.
My task is to explain what is a certified mediator, mediation party, mediator, and non-party participants. So, kaning certified mediator, na siya mediator which is certified by the Office of the ADR, and they also have successfully completed its regular professional training program. Tungod ana wherein naka-obtain sila certification which is para maka-facilitate sila resolution between the parties, and also kaning certified mediator, they also act as a neutral third party that will also help to facilitate communications and resolution between the parties. Next is the mediation. Kaning mediation, it means as a voluntary process or a confidential process also, in which a neutral third party or known as the certified mediator may help para mag-facilitate ng communication. And also, the goal of mediation is para ma-assist ang mga parties in reaching a mutually acceptable resolutions sa ilang conflict. Next is the mediation party. Kaning mediation party, mo na siya itong mga persons na na-involved sa dispute or conflict that is being mediated by a mediator. Next is a mediator. So, kaning mediator, mo na siya ang tao nga nakandak og mediation. And last is the non-party participants. Mo na siya ang tao other than a party or usa ka mediator. So, ang example ng non-party participants are the witnesses.
The scope of application of implementing roles of mediation is multifaceted, encompassing several key aspects. So, first, dispute types. These roles define the types of disputes eligible for mediation. This could range from civil and commercial matters to family disputes, workplace conflicts, over even international disputes. Number 2, participants. They outline who can participate in the mediation process. They typically includes the parties directly involved in the dispute, their legal representatives, if applicable, and the mediators. In some cases, other stakeholders like experts or advisors may also be involved. 3. Procedural guidelines. The rules establish procedural requirements for initiating, conducting, and concluding mediation sessions. This could include the time frame for scheduling sessions, protocols for communications between parties and mediators, and steps for reaching a settlement agreement. 4. Confidentiality. They address the confidentiality of mediation proceedings, specifying what information shared during mediation is confidential and how it should be protected. 5. Ethical standards. Implementing rules often include ethical standards and guidelines for mediators. These standards ensure mediators conduct themselves with integrity, impartiality, and fairness throughout the process, thereby maintaining the trust and confidence of the parties. 6. Enforceability. Depending on the jurisdiction and nature of the dispute, the rules may outline the enforceability of any settlement agreements reached through mediation. This could involve procedures for formalizing agreements and mechanism for enforcement in case of non-compliances. Overall, the scope of application of implementing rules of mediation is comprehensive, aiming to provide a clear framework for conducting mediation processes effectively, fairly, and in accordance with the established principles and standards.
Ad hoc institutional mediation involves the organization or institution engaging in mediation as when and needed, rather than having formalized mediation program in place. This allows the organization to address specific disputes or conflicts that arise on case-by-case basis, tailoring the mediation process to best suit the unique needs and circumstances of each situation. Ad hoc institutional mediation can be useful tool for solving conflicts efficiently and effectively within the organization, promoting a more harmonious and productive work environment, while annexed court mediation is a process where mediation is connected to court system either by court referral or voluntary participation by the parties involved. In legal disputes, the emphasis is on using mediation as a way to resolve conflicts before they escalate to formal court proceedings, offering parties a chance to work together to find mutually satisfactory solutions. Annexed court mediation can help alleviate the burden in the court system, promote more collaborate problem solving, and potentially lead to quicker and more cost-effective resolution for all parties involved.
State policy mediation refers to the process by which a neutral third party assists in resolving disputes or conflicts related to public policies between different stakeholders such as government agencies, interest groups, and the public. Mediation in the context of state policy aims to facilitate communication, negotiation, and consensus building among the parties involved to reach mutually acceptable solutions. The benefits of state policy mediation includes promoting transparency, fostering collaboration, reducing adversarial relationships, and enhancing the legitimacy of policy decisions. By engaging in mediation, stakeholders can work together to find creative and sustainable solutions that take into account the diverse perspectives and interests involved. Overall, state policy mediation plays a crucial role in promoting effective governance, enhancing public participation, and resolving complex policy challenges in a constructive and inclusive manner.
Do parties have the right to select a mediator? Yes. Parties involved in mediation have the right to select a mediator because the mediator must be impartial, independent, and agreed upon by both parties to ensure a fair process. The selection process involves joint agreement on the mediator's appointment, which considerations such as the mediator's expertise, style, biases, and rates being important factors in the decision-making process. Additionally, the mediator role is to facilitate communication as assist parties in reaching a mutually acceptable resolution without taking sides or making decisions for them. It is crucial for parties to choose a mediator who can effectively guide the mediation process and help them to navigate towards a successful settlement.
The task for this morning is to discuss with you about the qualification as a mediation. So, According to RA 9285, so this is not required a mediator shall have a special qualification or background or profession unless the specific qualification of mediator are required in the mediation agreement of the dispute.
When a mediator be replaced, if a mediator is selected to act such for any reason, the parties may, upon being informed of such fact, select another mediator. So in accordance with the Article 3 and 4 in the RA 9285, a mediator can be replaced under these specific circumstances. So first is the replacement scenarios. So a mediator may be replaced if they are unable to act, refuse, or withdraw from the mediation proceeding upon the request by any party, lack of necessary qualification, have questionable impartiality, violate ethical standard, and jeopardize party safety, or if the continuation of the process would lead to ethical standard. So, if that person is, if the mediator is, dili niya ma-fulfill ang isa ka rule as a mediator, dili niya ma-fulfill ang isa ka rule, so whether due to incapacity, refusal, or withdrawal from the mediation proceeding, so gi-ensure nga ang mediation process is makontinue gyapon siya effectively with the mediator who can actively participate. So, second is process of replacement. So, if the selected mediator is unable to fulfill the rule, the parties can choose another mediation upon being informed of the situation. So, the replacement mediator should meet the reasonable expectation of the parties and uphold the ethical standard. So, if ang mediator is bitaw dili bitaw niya ma-stand ang isa ka rule niya as a mediator, so ang parties is naay right to choose another mediation upon inform sa kana nga situation. So, if ang mediator is maka-violate og ethical standard or jeopardize party safety, or ang continuation sa mediation process kay mag-result siya og ethical standard, so ang party sub kay naa siya the both parties or the parties have the right to request a replacement to ensure that the mediation is remain fair, confidential, and conducted with integrity. So, this mediation process can uphold its principles of fairness, confidentiality, and effectiveness, ensuring that the parties can engage a constructive dialogue toward resolving their dispute.
A mediator may refuse or withdraw from mediating a dispute for various reasons. First is conflict the interest. If the mediator has a personal or professional relationship with one of the parties involved in the dispute, they may need to refuse or withdraw to maintain the impartiality. Lack of neutrality. If the mediator is unable to remain neutral and impartial during the mediation process, they may choose to withdraw to ensure fairness. Lack of competence. If the mediator does not have the necessary skills, experience, or expertise to effectively mediate the specific type of dispute, they may refuse or withdraw to prevent any harm to the parties involved. Unavailability. If the mediator is not available to commit to the mediation process due to others' commitments or scheduling conflict, they may need to refuse or withdraw from mediating. Violation of ethical standards. If the mediator's action or behavior violate ethical standards or guidance set forth by professional mediation organization, they may choose to withdraw from the mediator process. It's essential for the mediator to uphold ethical standards, maintain neutrality, and ensure that they can effectively facilitate the mediation process for the benefit of all parties involved.
This video continuing about what are the grounds wherein a mediator may refuse or withdraw as such. Example, ang mediator na ay bias or dili niya ma-settle jud ang both parties, so na siya possible na ma-refuse ang usa ka mediator. A mediator may refuse from acting as such, withdraw, or may be compelled to withdraw from mediator proceeding under the following circumstances. So, naa siya gipalo nga circumstances. A, if the safety of any of the parties would be jeopardized. So, if ang usa ka both parties mabutang sa alanganin ang ilang kinabuhi or ang ilang kuan, mao na siya, or mabutang sa panganib, mabutang sa delikado, mabutang sa alanganin. So naay possible nga ang usa ka mediator ma-refuse jud siya, kay dapat safety gyapon, safety jud ang both parties nga kuan sa dispute resolution. Dapat jud ma-settled unta ang ilahang panag-away. So naay possible nga ma-refuse ang usa ka mediator if mabutang ilahang kinabuhi sa delikado. Then sa F, if the mediator is unable to provide effective services. J, in case of conflict and interest. So kung ang mediator ay dili siya makahatag og kanang mga epektibong service, din wala epektibo ang ihang serbisyo usa ka mediator, so sa ihang serbisyo, so naay possible gihapon nga ma-refuse ang ihang pagka-mediator. Kay dapat ikaw usa ka mediator, naa jud kay accomplishment nga dapat imo jud siyang ma-settle jud na imong dapat efektibo jud ang imong serbisyo. Unya kini wala siya nakapaghatag og efektibo nga serbisyo, so naa siya'y circumstances nga mao ang ma-refuse siya or withdraw. Then so mao siya, and any of the following instances of the mediator is satisfied. So if naay gipalo kung satisfied ang mediator, so example, satisfied daw ang mediator pero na siya bias, bisan dili jud satisfied ang both parties for ang kuan niya ihang kuan nga satisfied ni siya, so na siya possible nga ma-refuse gihapon. Mao ni ang gisunod, one or more of the parties are not acting in a good faith. So bisan nag-acting na siya in a good faith nga ang mediator ming kuan sa iya ming angay nga nakita sa usa ka mediator, so ma-refuse din siya. Kay dapat sa usa ka mediator wala kay gilaban, wala kay labanan sa both parties. Dapat loyal jud ka ani imong pagka mediator, walay bias. Then Number 2, the parties' agreement would be illegal or involve the commission of crime. So, mahimo siyang, ang pagka inyong agreement, mahimo siyang illegal, din ma-involve siya sa commission of crime. Kay, dapat jud ka nang mag agreement jud mo ay ma-settle jud mo nga walay mga illegal. Then, number 3, continuing the dispute resolution would give a rise to an appearance in conflict. So, nag-continue ra gyapon ang dispute, continuing ra gyapon yung dispute resolution sa inyo sa both parties. So, naa siya'y mga naa siya'y mabubunga ng paglitaw na hindi na dapat. So, naa siya'y So, number 4, then continuing with the process would cause significant of the parties their minor children of the dispute resolution process. So, kaning sa both parties nga yan, continuing discussion ra gyapon sila niya, dili makuan sa mediator, dili makaya og settlement kini nga both parties na siya na process. Mao ni siya ang Article 3 IRR, then naay law nga RA 9285. Mao na siya ang alternative dispute resolution means process or procedure used to resolve a dispute. So, diri na sila maabot sa usa ka ang both parties diri na mo presiding judge of a court or an officer of a government. So, ang judge na moadto sila sa court na sila na ma-process, pero 30 days pa ni kuan kay on process, ma-process pa man siya, magkuan sila dito, mag-file of case, kuan dito na sila maabot dito sa court, dito na sila ma-settled kay dili man magpadayon ra man gud ang ilahang pakiglalis. So, pwede na siya maabot dito sa court kay ang magkuan na ang judge or officers of a government. Mao na ang maghawid sa ilahang, mao na maghawid sa both parties nga ga-conflict nga wala na settled sa mediator. So, ang mediator possible nga ma-refuse gihapon siya kay dapat ihadjong tagaag pagtagad nga ma-settled siya. Dili man niya ma-settled kay continuing ra gyapon ang duha ka both parties. So, magkuan siya process.
Number 1. One or more of the parties is not acting in good faith. It seems like there may be lack of trust or cooperation among the parties involved. Clarifying intentions and establishing open communication channels might help address concerns about acting in good faith. Number 2. The parties' agreement would be illegal or involve the commission of crime. If one or more parties are engaging in an agreement that would break the law or involve committing a crime, it's a serious matter. Such agreements are illegal and could result in legal consequences for those involved. It's important to avoid any actions that could lead to breaking the law. Number 3. Continuing the dispute resolution would give rise to an appearance of impropriety. Continuing to resolve the dispute would create the impression that something improper is happening. 4. Continuing with the process would cause significant harm to a non-participating person to the public. If continuing with a particular process or action would cause significant harm to someone who isn't directly involved or to the general public, it means that the consequences of proceeding could negatively impact others who are not part of the situation or decision-making process. This harm could be physical, financial, emotional, or otherwise detrimental. Therefore, it's crucial to consider the potential broader effects before moving forward. Number 5. Continuing discussion would not be in the best interest of the parties, their minor children, or dispute resolution process. Article 3 IRR RA 9285. Continuing the discussion wouldn't be beneficial for the parties involved, their minor children, or the overall dispute resolution processes. As outlined in Article 3 of the Implementing Rules and Regulations of Public Act 9285, this provision emphasizes the importance of prioritizing the well-being and interests of the parties and any minor involved, as well as the integrity of the dispute resolution processes itself.